introduce my very distinguished panelists. I've carried out a thorough capability assessment of each of them, and they all passed the test of contestability and innovative capacity. I'm not sure whether Bill is on the line. Is Bill Kovacic on the line?
Yes, he is.
He is?
Yeah.
Hi, Bill. If there are any godfathers of competition law and policy in the world, Bill is one of them, and very active, not just as at George Washington Law School, but as a former chairman of the FTC and other prominent roles. I don't think there's hardly any country in the world which has not asked Bill how to organize competition policy. So he will be telling us a lot of things which I think will be plain common sense to Stephen in his provocative way, but also to all of us. Diana, on my extreme right, Diana Moss is vice president of the US Progressive Policy Institute. She's been president of the American Antitrust Institute and also for 4 years in the Federal Energy Regulatory Commission. So she's seen it from both sides. Michal said to me just before, well, I've never been an enforcer, but she's been very close to them. So it reminds me of what someone said of their father, that he never hit me, but I could feel the blow of his hand. And Michal has been advising on antitrust matters for a number of years in several countries. Finally, if there is another godfather here, it's Fred Jenny, who's been since, I think, 1994, chairman of the OECD Competition Committee. He herded us like sheep or goats for many years when we appeared in his fora to discuss competition issues. He had always thought about the issues before we had thought about them, so the agendas were always current ones. That's someone referred earlier to the fact that we may or may not be in front or behind academics in our competition law enforcement. I would say that virtually all our records says that competition law enforcers are behind the market, maybe slightly in front of academics or slightly behind them from time to time. And that's one of the issues which we will be addressing. So I'm going to ask my panelists to reply to a number of questions which reflect our discussions this morning and Stephen's intervention. I think the first one is really to say plainly in relation to dynamic competition, have we properly addressed it in our antitrust enforcement in the US, in the EU, elsewhere? And I'd ask Bill to start off the discussion.
Go ahead without it. One thing I wanted to address was indeed the practical conditions in which these issues did come to both the Federal Trade Commission and the European Commission at the same time in Google DoubleClick. The Google DoubleClick merger features prominently in the AdServe case that Stephen was talking about. The Department of Justice essentially identifies Google DoubleClick as the missed opportunity to put competition policy on a different path. And one way to interpret the filing of the case is that it's an express effort to clean up a mess that was created by a non-enforcement experience. Again, notably, not simply on the part of the FTC, but on the part of the European Commission as well. And I thought I'd talk for a few minutes about the decision not to prosecute in the United States. I was a member of the Federal Trade Commission at the time. We had a full board, and by a vote of 4-1, the commission concluded that it would not take any action against the transaction. Why was that? Especially in light of a subsequent commentary that said this was a relatively obvious call that ought to have been taken. I guess when I look in the category of regrets, related to the earlier discussion today, I think we did have a knowledge deficit. We did not have a significant investment of effort made before the transaction in learning about the sector in question. The big research and development bets that we had placed over the previous 20 years had focused on the intersection between intellectual property and competition law and the functioning of the IP system, major expenditures to conduct proceedings on healthcare and competition law, a significant amount of attention given to data protection, privacy, but not deeply integrated to the discussion of competition law and policy. So when it came to analyzing the issues in question, I think conceptually we were several steps behind. Similarly, a lack of deep expertise involving the sector and the technology inside the FTC. We had a couple of attorneys who also had engineering backgrounds. They were patent lawyers. We did not have a computer scientist on our team. We did not have the quants who had spent their life doing the analytics work that makes a good deal of the sector operate. We did not have, in short, the broader base of capabilities that one would associate today with the Competition and Markets Authority and its extraordinary tech and data group. We simply hadn't built that yet. I think what it meant was that we were not in the position to inquire about the effects of the transaction with the same sophistication that we needed. There were complainants, to be sure, who came forward and tried to provide that kind of deeper tutorial. But ultimately, I think there's no substitute for having your own indigenous capability. And then I think the steps that the CMA have taken and other agencies are taking to acquire that skill is a strong recognition that to do effective work in this field requires having the right people with the right research agenda and the right body of knowledge to understand what's taking place. So I do see this as a painful example of an enforcement authority that to some extent lacked the expertise that it needed to do the job well. But I think a lesson from that agencies have developed is to build that expertise in order to do work in the area. Another factor that was important was the timing of the transaction. And this is more of a political science, public administration explanation for what took place. But the FTC, at the time that the Google DoubleClick transaction was examined, had lost 3 preliminary injunction actions in a row. These were 3 efforts to go to court to block transactions. We had been rebuffed in all 3. In 2 of those, at a later time, we succeeded in recovering a favorable decision on appeal. But at the moment, we had lost 3. And this one was going to be a comparatively difficult case to litigate. It would have been the first litigated vertical merger challenge in roughly 30 years for the DOJ and the FTC combined. It would have involved educating a court about the significance of the vertical stack, of describing how this acquisition by a company that did not even have a 20-year track record yet. Google was still a relatively new company, that it would have a potentially significant adverse effect on the development of the sector over time. In short, and Google would have brought forward justifications that would have pointed to the better user experience that would have come from the transaction. So a still developing and somewhat turbulent sector, a relatively new actor, that being Google, a vertical theory for which justification evidence would have come in and imposed this. I suppose in my own mind, it was a great concern that we'd not be in the position of losing the fourth in a row. What happens if you lose one, of course, is that there's a great deal of concern in the broader news market that you've lost your touch. You lose two, things have collapsed. You use three, it's the apocalypse. You lose four in a row, and it's a sense that your capacity to effectively apply merger law has simply disappeared. So I wasn't keen on taking a chance with the fourth. There was an alternative that we didn't think of that would have given us more time. That would have been to, instead of seeking to prohibit the transaction, to use our internal administrative process, which would not have yielded an injunction, but would have given us more time to gather evidence, explore the evidence, examine some of the issues in question. I do regard that as a missed opportunity to use capabilities that certainly were inherent in the design of the FTC, but did not stand out for us at the moment. I suppose a final observation is that if you go back over a period of decades, certainly in the post-World War II era, you'd seen the FTC engaged in a number of projects that involved the assessment of competitive effects in highly dynamic, technologically sophisticated markets. When I go back and look at some of the output of those specific initiatives, I notice how the agency did not have a particularly effective way of carrying out what today is called knowledge management that lets you summon up the lessons of what you've learned from these earlier episodes and bringing them to bear on the problem at hand. In too many instances, the knowledge gained had been forgotten. And among the most important lessons that were not applied effectively were those gained in evaluating transactions in the aerospace and defense sector, where the FTC had spent a lot of time developing a capabilities-based framework to determine the significance of competition between the merging parties, but also the possibilities for competition that might emerge in other parts of the defense supply sector. So not a particularly effective way, not an effective mechanism internally at the time to bring to bear what had been learned in these earlier episodes to the analysis of the transaction at hand. And I would welcome, and this is suggested in the report that Diana Moss has made available to all of us, I would welcome an effort to deconstruct that transaction and its review that engaged both the European Commission and the FTC, perhaps parties that were acting as advocates, to discuss the decision-making process with an eye towards asking, what did we miss that we should have seen? And how does that get incorporated into the development of future merger review proceedings? To some extent, that's happened. There's been a great uplift, I think, in the human capability, the knowledge investment side of things. But other areas, I think, would be illuminated much more by that kind of examination. Even though enough time has passed, it could still be somewhat painful and awkward for the participants. But I think that would be a broader discussion worth having. Thank you.
Thank you, Bill. You've emphasized that if we talk about dynamic competition, we have to have inside agencies a full in-depth investigation of all the effects concerning the conduct or the transaction involved. And that means, first of all, that the competition authorities themselves need to equip themselves with the resources to be able to deal with issues which they have not dealt with before, particularly in the technological field, data scientists, as well as behavioral economists and behavioral scientists. And that you emphasize too, we've got to be in a position vis-a-vis events in the market to be at least at the level of understanding general commentators in the sector, rather than just waiting for things to happen. We've always been accused in the European Commission of having long investigations, but then finally taking a decision too late in relation to problems which no longer exist, or at least exist later on. Now, I'm going to ask Diana to comment now, because she's written a very nice article on these issues.
Thank you. And thank you very much to DCI for inviting me here today. It's really an honor and a pleasure. The question is, have we addressed the dynamic competition question? And I think the answer is not yet. And I think a major impediment to that, at least in the United States currently, is the current orientation around the use of antitrust enforcement as big as bad. So until we distance ourselves or recast or reframe the big is bad narrative that we see right now through the neo-Brandeisian movement, I think we're going to have a much steeper hill to climb in introducing the notion of dynamic competition. That said, I do think that the capability is there, as we've already discussed on the panel. The agencies all around the world are full of very talented individuals. I think they have inquiring minds that want to know. But I also think, another impediment is this fundamental information asymmetry between competition enforcers and industry. We see those information asymmetries reveal themselves in very run-of-the-mill cases involving manufacturing, the crafting of merger remedies that often fail, and other types of, more bread-and-butter antitrust enforcement. I think that problem, that information asymmetry problem around framing dynamic competition theories and evidence is going to be a problem. But I will say this. I think the decision or the question to introduce or create a shift or a duality of policy around dynamic competition and a more standard static approach, and they can coexist. I think it's a policy issue for enforcers. Competition policy is different than enforcement. Because it invokes different tools in the toolkit: sector regulation, other forms of law, data privacy, intellectual property law, et cetera. But any decision to create this duality in policy approaches really affects all aspects of competition enforcement, from theories of harm to evidence to treatment of entry, as Stephen said earlier, treatment of efficiencies. And I don't think the case has been made yet for why we don't have any competition policy, at least in the digital sector. And that's a big sector. The digital transformation is charging ahead, leaving enforcers somewhat behind and getting further and further behind. And when I say digital, I'm not just talking about the big digital ecosystems. I'm talking about the incursion of digital technologies and digital commerce in every sector. We see it now in fintech. We see it in health tech. We see it in agricultural biotechnology. The digitization of the economy is ongoing. And so we're not just talking about Amazon and Google and Facebook and Apple. We're talking about all sectors that are going to be increasingly relying on digital technology. And that poses real challenges for enforcers. The business models are very unique, right? We're now seeing a very a highly integrated engineering economic business model in the digital ecosystems containing a platform, cloud technology, and applications. We see unique economic features. We see network effects. We see information asymmetries. We see economies of scale in cloud technology. We see data externalities. These are business models that are teeming with market failures, although I take the earlier point that may be a little bit overblown. Most important, the digitals tend to grow through acquisition. They do not grow organically through internal R&D. And they are also some of the most dynamic and productive sectors on on the planet. So we have antitrust enforcers in this really difficult position of trying to play catch up in the digital sector, but against the backdrop of highly dynamic and highly innovative sectors. So what we can say, and I'll finish on this note, that we have no policy, no competition policy. We need to define one, and that definition should include concepts of dynamic competition. We do not have any shining examples of enforcement success. The US is relying almost entirely on monopolization cases after 25 years of virtually no merger challenges in the digital sector. That is a very expensive and resource-intensive way to discipline or manage competition in a sector. Europe is also no panacea, with all due respect to the Europeans in the room. That is a form of ex-ante compliance. I'm a former sector regulator, and I did regulation 24/7. And that is a very, very different approach, which is also not proving up immediate benefits. So I think cracking open this question of have we addressed the dynamic competition issue is really going to call into question how we use enforcement tools, merger control, monopolization law, and laws around anti-competitive agreements such as algorithmic collusion. And I do not think at this stage in the game we have a really good sense of how those tools can and should be deployed under a new model.
Thank you, Diane. That means we have a yawning gap to fill. And I'm going to ask Fred whether we can fill it.
Thank you, Philip. There are several dimensions, I think, that we should have in mind, because I'm a little unsure about what our debate is all about. The first question that I think we should ask is, getting back to the question you initially raised, whether we have properly addressed dynamic competition in competition enforcement in the US or in the EU, is what do we mean by properly? And I'm not sure what the answer to this is. The first thing is properly has to be defined with reference to what the goals of competition law are. The goals of competition law are, to me, very difficult to find. They're shifting all the time. In the EU, I mean, we went from a period when Mario Monti said, okay, consumer welfare is the goal of competition law, to debate between in the ECJ, where the issue was whether there was another goal than the achievement of the single market to competition law, to Ariel Ezraki paper looking at decisions of the ECJ and reconstructing what the goals were and finding an enormous diversity of possible goals. Now, I'm asking this because it seems to me that one of the questions which is underlying our debate is whether the dynamic competition approach considers that innovations are good in themselves, and whether this is the same concept that we have in competition law, or whether we think in competition law that innovation are good or interesting only to the extent that they've been translated into benefits for consumers. Because if that is the interpretation of EU law, then it means that innovation in itself is not the goal that we pursue. What we pursue is something else. And I think that we have to be clear on exactly what we try to achieve there. The second point is, I think that when we talk about innovation, we have very loose talk, and that maybe in terms of consequences of innovation on competition, and I very much like the approach that suggests that there's an interrelationship between competition and innovation which goes both ways, and that is the dynamic part that we should have. But my question is whether when we use leapfrog or disruptive or incremental innovations, can we expect to have the same kind of analysis when it comes to the impact on competition? It seems to me that if we're talking about incremental innovation, then we can stay pretty much within the confine that we have. But if we talk about disruptive innovation, we may have monopolies replacing other monopolies, which from the competition point of view may not be satisfactory if we think that consumer welfare should be the essential value of competition. So I think that maybe we need, first of all, very clearly, we need to explore more in detail the relationship between competition and innovation, and this has been, I mean, it's quite extraordinary, in fact, that there's been so little innovation in this question over the years in the competition law enforcement. But B, maybe there are, earlier on, there was an assertion that the innovative process was quite different from one sector to another. So whether we have differentiation by sector or differentiation by type of innovation, we need to be possibly more precise about this. The third issue is, of course, how do we operationalize the dynamic competition approach? And I think that this is quite important. I think that there's been a wide consensus around this table that we need to do that. But it seems to me that this was already the consensus last year and the year before last. And I'm not sure how far we've gotten in really. And I'm saying this because I think we've heard, and here I must say that I'm quite shocked to hear Philippe, Lowe, and Diana say that competition authorities require specific resources to engage into dynamic competition capacity analysis, because I've just heard on the previous panel that this is exactly what the EC does when it looked at the Adobe Figma merger.
It's getting there.
So they already have the resources, clearly, otherwise they wouldn't have been able to do the analysis. But more seriously, what is behind this is we've got very loose talk when we talk about, when we say we've done the analysis. What we need is a framework from the competition agency. It would be extremely useful to have, if that kind of analysis is indeed conducted, to have a guideline that would tell us what are the questions that the competition authority, I mean the DG Comp, will ask, and therefore to be able to prepare to answer those. But to get this guideline, probably the economists who are thinking about this could help by proposing a set of framework, at least possibly simplified and incomplete originally, but at least to get us started on the road to try to operationalize this for a competition authority. One of the things which we have not talked about and which has bothered me since the beginning of the day is two strands of literature. I completely agree with what has been said about the fact that there can be cross-fertilization between the business literature and the economic literature, and that we absolutely need to do that. But within the economic literature, there are two strands of literature which don't seem to be entirely consistent with each other. One of them is the literature on path dependency of innovation, where the idea is that powerful firms can orient the direction of innovation through their decision of their transactions, and therefore they can herd the innovation in a direction which is favorable to their own interests rather than to the general interest. And the dynamic competition approach, which seems to assume that the capacities of the firms is the only thing that you have to worry about, and you don't need the context of the historical context, which has possibly biased or at least herded the innovation in a specific direction. So I think it would be good to try to also include that literature to try to solve that question. And finally, there's the question, but this goes back to what I was saying originally, is it obvious to us that dynamic competition, which is certainly going to be very useful to try to allow for and recognize more innovation, but really, does it necessarily eliminate market power? If that is the issue for competition authorities, it is not entirely obvious to me that there cannot be a gap. I mean, in some cases, clearly innovation will eliminate market power. In some other cases, it will replace market powers by another market power. What should competition authorities do with that? I mean, and so it goes back to if they think that innovation is clearly the most important goal, the promotion of innovation is clearly the most important goal of competition law. I mean, they should take this into consideration. If they think that it's consumer surplus, they probably would be neutral or don't consider that this is necessarily an improvement of social welfare.
Thank you, Fred. I mean, as you say, we've got to be clear about what the goals are. I think Mario Draghi added another one, which was competitiveness, and said, should we deal with this? Well, he raises the question, should we deal with this in the context of our competition assessment, or should we justify certain conducts or transactions on the basis of an exception, whether it's security of supply, whether it's competitiveness of the nations? That's a really important point. I'd like to come back to the issue of guidelines and regulation afterwards, because predictability is a concern of quite a lot of people around the room. You know, what is the policy? Anna raised this as a question, what is the policy? But once we've got the policy, should we tell everyone what it is, or are we just going to hide behind a bush in the garden and jump out like a cat as a company if we don't like them? Now, Michal's going to bring us back, I think, to one of the more practical aspects of looking at the digital sector, which is, and this, emphasizes what Anna and myself have said about knowledge and expertise in markets, which is the practices which we are unaware of, or the practices indeed such as algorithms, which even companies themselves are not aware of the impact of immediately. They learn, as I think Ariel has pointed out, through a Markov process. They improve, they discover to their delight that things are going their way, but sometimes they go the other way. Michal, the floor is yours.
Thank you very much, and thank you for having me. This is a wonderful setting with so many people that I look forward to talk to. And let me start, Philip, by going back to your initial question, which was, have we got it right? And I think the short answer is only partially. And then it begs the question, why? What's driving this? Let me offer two kinds of capabilities which I think are missing or were missing. One of them is the capabilities offered by economists and by legal scholars, because what we know today, for example, relating to network economics, we did not know 10 years ago. Okay, so it's developing as we go along, and I think that even if some of the knowledge was there, as we saw today, as we heard today, there's a lot of bridging to be done. And I think that this is a very important, and the bridging right now is not only between economics and law, but it's also between data science and computer science and law, and the three together. So I think this is something that we are developing, but we're not there yet. The second type of capabilities, which is very relevant here, is the capability of regulators. And we talked a lot about the capabilities of competition authorities, but I think that a lot of it is also the capabilities of courts, which are in the background. And actually, when a competition authority decides whether to bring a case or not, it should ask itself, what is the court at the end of the day going to say as well? So if we don't have the capabilities there, if regulators, if courts do not understand the economics or the data science behind it, that's going to be really difficult. And I want to give you examples of these kind of dynamics. I have three here, okay? So the first is with regard to network theory, because network theory is something we all know about in this room. We talk about network effects. This has been the basis of the great reports from 2018 and a lot of writing afterwards. But we generally assume, especially in the legal context, we assume that network effects generally create, or they might create in some situations, winner takes it all dynamics where you have first mover advantages that entrench monopolies. And just think about the Facebook as the ultimate example here, why it's so difficult to then create a competitor, because we all have links, right, that we don't want to lose to our Facebook friends. But is this necessarily part of network economics? The answer is no. If you look more carefully, and Raza Granat has done that for us into network theory, actually network theory sometimes flips this on its head. And this is once we stop assuming that all the nodes in the network are similar. Rather, when we think about the fact that, for example, in Facebook, some people have many more links to others, and so some nodes are much more important. For example, compare my Facebook page, which I rarely use, to that of Ronaldo's, okay? His place in the network is so much more important that he affects the agility of the network, okay? So, whereas in a network where all the nodes are the same and they have the same number of links, it takes up to 70 or 80% of the removal of the nodes in order to fragment the network. The same is not true with regard to a network where some nodes are more important than others. So if I want to compete with Facebook, I can take Taylor Swift, I can take Ronaldo, I can move them to another network, and that would create a different competitive dynamic. We're talking about capabilities, we're talking about dynamics. This is something that was not considered, although it was in the literature. This is not new. If you ask a physicist, they would tell you that this has been in the literature, for at least 20 years. So I think that we need more of this cross-fertilization between the different strands of writing and scholarship. Second point, okay, second example is regard to the application of traditional doctrines to algorithms. And a lot has been said about, and a lot has been written about how algorithms affect market dynamics, especially with regard to coordination. And Ariel has written, together with Chaim Firstman, right? You've written one of the wonderful articles in this space. And we all understand that algorithms, they bring speed, they bring sophistication, they bring lower costs, they change market dynamics. However, I mean, it's not only the ability to coordinate that they change, they also change the ability of firms to analyze better willingness to pay. And if you think about it, willingness to pay sits in the basis of a lot of abuse of dominance cases: discrimination, high prices, selective pricing, predation, etc. They also can reduce the level of uncertainty by signaling to other firms, which again is something that sits at the basis of a lot of the economic models. So in one of my recent papers with Jorge Padilla, what we did is we applied decision theory to create a typology of the effects of algorithms on current competition laws, because a lot of the current competition laws embody assumptions about how humans operate and how humans can reach decisions, or how humans can calculate different conditions, especially in a fast-moving world. However, once you introduce algorithms, that might not be the right way to go. And just one example here is with regard to hub-and-spoke scenarios. These are scenarios where rivals rely on their decisions. It might be pricing decisions, for example, on the same provider of algorithmic decision-making services. And of course, there's a need to balance pro and anti-competitive effects. But just to take the example of current US law and talk about the capabilities of courts to understand what's going on here, what we see is that courts are not sufficiently amenable to the task, and they create false negatives. So one example is, for example, a case against hotels on the Las Vegas Strip, which all used a third-party pricing software to aggregate their pricing information, and that this aggregation affected the pricing recommendations produced by the software, which were then used as a basis for pricing the room offers, and that increased prices for the Las Vegas Strip. However, the case was dismissed. Why? Because the court said that the plaintiffs failed to prove that the hotel operators were required to accept the prices recommended. Now, such a requirement is problematic, especially if rivals are aware that everybody else is using the same software. Not only that, there have been some studies about the psychological effects of algorithms. So a ProPublica investigation revealed that when renters when prices were suggested by algorithms and the prices seemed too high for them, they said, well, the algorithm is probably right. So there was even a psychological effect of adopting the prices suggested by algorithms. So all these need to be taken into account. Final example here is with regard to remedies, because I think that we're talking a lot about the substance of the law, but I think that where we really got it right, where we really got it wrong, is with regard to remedies. We tried, but the remedies were insufficient. I mean, there's a lot of writing about how, for example, financial remedies are inefficient, but also other remedies did not go far enough in order to restore competition in digital markets and to think outside the box and to be a bit more interventionary. So Nicola and myself, a few years ago, we decided to just think outside the box, and we wrote a paper which is called Radical Remedies. And I think from there, I mean, we were going crazy with our ideas, but one of them I still think is very practical, and that's the suggestion that instead of sharing data, which we see is quite difficult, we talk about interoperability, we talk about data standardization. I mean, this was mentioned this morning as well. One idea that we had is sharing the algorithm rather than the data. And the idea is that especially when one firm, a monopolist, has gained its advantage by creating artificial barriers to access to data of rivals, which meant that only the monopolist could have accessed the data. A monopolist now has learning from these data, which is incorporated in the algorithm. One way to restart the market is by sharing that portion of the algorithm that learned from the data which was illegally or manipulatively or accessed by limiting access of competitors. And of course, we go through all the analysis. Last word here is that listening to the discussion this morning, extremely interesting, and especially, David, to your own remarks, I had one concern, and I would love to talk with you about this afterwards, which is we might find ourselves in a situation where courts apply both static and dynamic capabilities analysis. And that might be even worse than we have today because they raise the barrier even higher. So thank you.
Right. Michal, we'll come back to that point later on, but your last point. But I think what you've said follows on well from what Bill and Anna have said, that we really got to get streetwise about what's going on in the markets. And come back to the point about resources. Yes, we may have got them, but we haven't used them effectively enough to do it. I'm conscious of time, and probably Nicola's going to tell me to stop soon, but I just wanted to ask a quick quick question of all of my panelists, Stephen maybe not yet. To what extent do we need to announce policy and with presumptions, with regulation, with guidelines in advance? After all, an enforcement authority has got limited resources, and one of its tools, apart from taking decisions against a company, is to provide a deterrent against certain actions. If you don't provide a deterrent, you probably lose 20% of your resources straight off, because you have to take cases each time. Now, the criticism of the European view is, well, you've got ex-ante regulation, it's going to be very difficult for you to implement this effectively. It'll be about compliance, not about looking for market growing solutions. The criticism on the other side is, yes, and I fully respect, I mean, three of us, Fred, Bill, and I, have been on non-executive directors of the CMA, so we're very proud of the CMA's investigative possibilities. But if it has to investigate everything, they may be in a difficulty to come up with an enforcement record. Now, I'm only opening these questions as an issue to be addressed. Once we've got the policy which Anna has advocated, once we know what the objectives are, as Fred has said, how much do we need to put into some degree of deterrent regulation or guidelines to make it work? Fred, first of all.
This is a very wide question, but let me take one example that I think would require a guideline, because if not, we don't know what we're talking about. It was said this morning that the standard of proof, which has been required by the Court of Justice for mergers, is the fact that the merger is more likely than not to lead to a decrease in competition. Well, when we come to the particular issue that we're talking about of dynamic competition, innovation, etc., this is not the standard of proof. The standard of proof for potential entry, which is part of the analysis, which is what we are talking about, is that the entrant is, or the potential entrant is very likely, so it's not more likely than not, it's very likely to enter the market in a relatively short period of time. So the question really is, can we use dynamic innovation or dynamic analysis to meet these standards? And there are at least three questions that we need to ask, and on which it would be absolutely useful to have at least some guideline. The first one is, can dynamic competition analysis tell us that a firm is very likely to enter? In other words, is there, we know that they have the capacity, but does that tell us, or does the analysis go far enough to say that there's also the intent or the likelihood that is going to enter? The second question is to enter a market. What happens if it displaces a market, which may be the case of disruptive innovation? How do we interpret this? Because literally speaking, it's not entering a market, it's making a market obsolete, and so does that apply? And the third thing is, David, in his presentation this morning, said that the dynamic competition is in a long-term perspective. So can we use this for a short period or a short time to show that an innovator is very likely to enter in a short period of time in a market because it has the capacities, which and therefore which capacity? I don't think that we can have this analysis without having a guideline that is going to tell us what is expected to bring the proof. So I don't think that guidelines slow down the movement. I think they can accelerate the movement.
Yeah. Michal?
again, this is such an important question, and I think that in my mind it connects to the debate with regard to standards versus rules, because in one sense we have it all, right? We have it in the standard, very wide standards that we have in some competition laws, but then how do you apply it? And it becomes a very tough question, especially if what's changing is not only the industry, but it's also the economics or understanding of economics, which is changing, which makes it a much more difficult question. So I think that one way that I would think to go around it is, first of all, to go through guidelines, and second, to bring cases or write opinions, but have only declaratory remedies or no sanctions.
Thank you. So a good question, to be sure. I think the answer is yes, at least in the dynamic competition context. Given the ongoing state of learning and the recognition by enforcers that these concepts are important, it would be helpful. But we know agencies to be somewhat reluctant to issue a lot of guidance. In the United States, at least, guidance tends to, it's not binding on the courts, but the courts pay a lot of attention to guidelines. But by the same token, we have very little guidance right now in the US. We had no vertical merger guidelines for 3 years, from 2020 to 2023. We still have no remedies manual at DOJ, which was pulled. The FTC's remedies guidance is now 12 years old. A lot of these documents have been taken down and not replaced, and I think for matters of transparency and predictability, it is important to think about this. But my one caveat is this, because dynamic competition is sort of a work in progress. Enforcers go into cases in the decisions to investigate and bring enforcement actions. They're already thinking of how to fix the problem. They're jumping to the very end game. And those of you who are enforcers or former enforcers know this. We always approached a competition problem by saying, okay, let's figure out how to fix this problem if in the course of our investigation we discover that there is a competition problem. So I think that would put the focus on the agencies issuing guidance on remedies. And I call for this in my recent paper on the lack of digital competition policy, especially in the digital sphere, because remedies may look very, very different in digital than in any other non-digital sector. For example, breakups. You're talking about breaking up highly integrated ecosystems and a unique business model. We're talking about injunctive relief, for example, no more exclusive contracts if you're a monopoly. Behavioral regulation could start looking like de facto regulation, which has some downsides. So I think if the agencies gave a lot of thought to the end game, which is how do we fix problems if we apply a digital competition framework in, say, the digital sector, what would those remedies look like? And I think that would go a long way to guiding industry on making consolidation proposals or deciding whether to engage in certain forms of conduct. But the long and short of it is I don't think the agencies are at a place now where they could issue guidance, for example, on how they would be unpacking mergers and conduct in a dynamic context. I don't think they have they haven't advanced to that point yet. But remedies, that's a different story.
Thanks. And Bill, have you a view, ex-ante regulation?
Yeah, I think I'm a bit more sanguine on the question of whether the agencies have knowledge that would be relevant. Do they have accumulated experience that would be informative? Do they have a lot to say based on earlier encounters with highly dynamic sectors to say a lot that's informative about the current context? I think they do, but I think there is a fundamental problem in aligning incentives in the public policy making process to bring that all to bear. I mean, the metaphors that have been discussed today, building bridges, drawing connections, building networks, these all involve a significant investment that means foregoing some amount of current consumption for the sake of building a foundations, infrastructure that supports policy. That's not often a key priority of incumbent membership and leadership at different boards. It's very hard to develop a culture, a custom that says these kinds of investments are useful. I suppose a benefit of the deliberations we're having today and through the week is that it draws attention to how important these investments are. But I think, again, in looking at a number of different settings in the past, agencies used a variety of different tools. They brought cases, they convened conversations, they published reports, they issued soft policy instructions that in some ways resembled guidance. They gave speeches. They worked with other agencies. There are a number of significant episodes, I think, from the past that show how this can be done. But none of it is free. It involves a decision to commit resources to doing this and building a comprehensive strategy. That institutional obstacle, I think, is one of the biggest barriers to carrying this out. But I think, examined closely, there is a lot of previous experience that suggests what the analytical techniques are and the methods for promulgating policy.
Thank you, Bill. Nicola, I'm going to telescope the rest of the questions and try to summarize what we've been hoping to discuss. And then I'll give the floor to Stephen for his final remarks. I think we've learned this morning that we've come a long way in looking at digital markets and digitalized markets, but we're not there yet, as Anna's expression has expressed it. We know that market definition alone in isolation doesn't take us very far in a world where there are ecosystems and different dynamic effects. We seem to have quite a lot of instruments at our disposal in antitrust mergers, in legal terms, but it's the question of how we use them on the basis of what tests. The tests depend upon more detailed knowledge. Maybe they can be reflected in guidelines. Michal says they can also be reflected in case law, but don't forget we're enforcers. Effective, timely enforcement means you've got to use scarce resources in a limited amount of time to produce a result which people feel is credible in terms of its impact. Now, I think that the jury, therefore, is out on that question for all competition authorities at the moment, because we're struggling to get to the point where there have been credible decisions. It looks in the European jurisdiction and in the US jurisdiction that there are some cases which might provide some benchmarks. We've also brought on board the importance in the last panel of capability assessments, which should be more structured and more visible to everyone. I can't personally think of any dynamic competition analysis without an analysis of corporate behavior, and not just incentive, but also capability and potential impact over a certain period of time. These are essential parameters. So we're somewhere along the road which Nicola and David and others want us to be, but we're not there yet. Stephen, you probably think we haven't even started. Sorry.
No, far from it, actually. I would just make two very brief comments in conclusion. The first is that I think it would be delightful if the aspiration is towards consensus-driven guidance, because that would fundamentally differ from the very negative big is bad narrative which opposes this more evidence-based approach. And indeed, that was the experience with the generation of guidelines in the 1990s and 2000s, which sought and achieved a lasting consensus. But that, of course, is a mountain, as has been alluded to. So what are some immediate steps? I'm conscious that we have a representative of the CMA with us, and there are many opportunities in the current case law to set some of these precedents in a new regime, which would be a first step on that hike.
Yeah.